So, hello everybody. It is 1 o'clock Eastern time, and we are ready for another webinar where I am happy to answer any questions you have about estate planning documents. So, thank you all so much for joining. Uh, I will start, as I usually do, with a little story about how Legal Wills came about and my role in the company now. So, I am one of the co-founders and I am the CEO of Legal Wills that started 25 years ago. And it started at a time where we realized that ourselves, myself and my co-founder, Henry, and all of our friends who all had families and jobs and assets, uh, none of us had a will in place or any other estate planning documents in place. And everybody that we knew that it was a very important thing to do, but we hadn't got around to doing it. And we were in our 30s or 40s. We knew it was the time of our life where we probably should have had these things sorted out. We certainly had responsibilities, but we hadn't taken the time to get certainly our will and power of attorney, living will, those other documents, we hadn't taken the time to do it. So we weren't sure why. We realized that there were barriers to writing the documents, whether we didn't think it was as much an affordability issue as more a convenience, making a time to make that appointment with a lawyer, coordinating that with other family members. It just wasn't getting to the top of the to-do list. So that's when, back in 2001, at the height of the dot-com boom, myself and Henry decided there must be a better way. There must be a way that we could remove the barriers to preparing these important documents. And that was the seeds of an idea that became Legal Wills. So here we are 25 years later, and we have a service that is available in Canada, in every province, bilingually across Canada. We're also available in the US, in every state, with the one exception. Actually, we're not available in Louisiana, but in 49 out of 50 states, we are available in the US. In the UK, in England and Wales, we do not currently support Scotland, Northern Ireland, but we do support England and Wales, and also in South Africa as well. Maybe I'll get to why we have those gaps in today's webinar. But what I would want to say is that if you have any questions about the documents that we support, the way our service works, the way our company operates, and what you need to do to get these documents prepared, I am very happy to answer those questions. But as always, I do start it with a disclaimer to say I am not a lawyer. I am not a tax advisor. I am not a professional financial advisor. So I cannot give you any professional advice specific to your situation. And certainly I cannot give you any legal advice. It would be against the law for me to provide you with legal advice. That would be what's known as the unauthorized practice of law. That's me passing myself off as a lawyer when I'm not qualified to do so. But I can certainly answer any questions that I, in my judgment, regard them as common knowledge or generally available answers that if you searched, you could probably find the answers to these questions. So not specific to your situation, but certainly answers, commonly asked questions and answers to those questions. Please, this is going to be about half an hour, so please throw any questions into the chat. Very, very happy to address any questions that are put into the chat. I think when I answer the questions, I tend to have a Canadian bias because I'm based in Canada, and we find that the majority of our customers are in Canada. So I would not want to answer a question if somebody's asking a question from anywhere else in the world. please let us know where you are, or let me know where you are. I may be able to answer the question as it pertains to the jurisdiction that you're living in. I would be fascinated to know if anybody wants to put into the chat where you're located. That would be great. I would be really interested in getting a feel for where people are joining this webinar from. But with that, I do have some questions. We have some questions that are sent in ahead of time. I answer any questions. I'm going to put that back up as well. If you want to ask me a direct question, you don't want to be asking it on the webinar, but you want to ask me a question directly, tim@legalworlds.ca. You can send a question in there. I answer all my emails. So more than happy to take it outside of the webinar if you have something that you're not sure about with respect to these documents. So I'm going to tackle some of the questions that come in either through our support ticketing system or that have been directed to me in the last week. And there's something to note there as well, that if I do not get to a question that you have, or I don't answer something adequately, we do have a customer service team. And I did touch on this at the last webinar, that you can get in touch with us by sending in a support ticket. You can phone us. We have a chatbot on the website as well, and you can even book a call to have somebody call you back and have a live one-to-one with a live person who will be able to listen to you and go through any of your concerns. So we do have a number of channels to send questions in. So absolutely, and this is one that has come in recently. People asking about, they hear about this residual estate. What exactly does that mean? Why is there a residual estate that is referred to in the will? And it's a really important concept. It's not language that we use every day, but it's a very important concept in the will, because the way the will works is that it's read in order of how things are written in a document. And all of your assets are gathered up by your executor, or it's kind of conceptually gathered up. The executor knows what all of your assets are. There's certain things that have to be done first after you've died before everything can be distributed. Your debts have to be paid. Taxes have to be paid, and your funeral expenses have to be paid. So those three things come out immediately. They come out off the top. Debts, taxes, funeral expenses are the first three things that come out of your estate. Then, after that, there's any specific items that you may want to go to an individual beneficiary. So you may say, I want everything to go to my spouse. Oh, except for my piano, because my spouse doesn't play the piano. But my niece, she plays the piano. So I want my piano to go to my niece, and then everything else to go to my spouse. Or you could say, you know what, I want $5,000 to go to the mission, the inner city mission to help people who are struggling. You can do that. That's a specific bequest. So those specific bequests will then be paid out, and they could be items, they can be sums of money, but those specific things go to those specific beneficiaries. Then there's everything else. And that everything else, where it's possible to get tripped up if you're attempting to write your will yourself, is an attempt to try and list everything you own. And you don't want to do that, because your will's not going to come into effect today. It's going to come into effect a week from now, a month from now, a year, 10 years, 50 years from now. It's going to come into effect sometime in the future. And you don't want to have to update your will every time an asset changes or every time you acquire something. Every time you get a new car or open a bank account, you don't want to have to keep going back to your will and updating it to say that you've acquired something new. So that's why your will refers to everything else. So the debts, the taxes, the funeral expenses, and those specific bequests go, and then you've got everything else. And that's whatever you happen to own at the time of your death. And it's up to the executor to gather up. And that's the residual estate. Now, that residual estate doesn't have to go to one individual. It can be divided. I say everything else will be divided in equal shares between my two children. You can absolutely do that. So you can divide the residual estate, but you don't have to say what's in it, because quite simply, you won't know. You won't know what is in that residual estate, and only your executor will know after you've died. So the obvious question is, how's my executor going to know? How's my executor going to know what all of my assets are if I don't list them in the will? It's a really important point, because, they shouldn't be in your will, but they should be somewhere. Somewhere you should be documenting everything that you own. Your executor, imagine trying to write down everything you own, and you think, oh, what a pain that is. That's a big job. Yeah. Imagine your brother-in-law is your executor. How on earth are they going to be able to write down everything that you own? They're not going to have a clue. So somewhere you have to provide a list of people to contact, subscriptions to be cancelled, debts that are owed to you, people, just bank accounts, online accounts, trading accounts, every asset you have. That could be domain names that you own. It could be just make a list of your YouTube channel, any revenues coming from online ventures that you may have, any business assets, shares that you own. Everything's got to be documented so that your executor is going to know the scope of all of your assets. If you don't do that, the executor is never going to know that they've completed their work. That includes, I have $5,000 in the back of my closet in the shoebox. That's got to be in there, because otherwise your executor is not going to know, and that can go missing. In fact, every bank, like the Bank of Canada, the Bank of England, they have a list of assets that have come from unclaimed bank accounts. These are bank accounts from people who have died, and the executor never even knew it existed. And the bank doesn't know that this person is not alive anymore. So you can have unclaimed assets. So to avoid any of your assets becoming unclaimed and going to the Bank of England, Bank of Canada, Federal Reserve, it's important to make sure that it's all documented. At Legal Wills, we do have a service. We have a service called My Life Locker, and that guides you through the process of making sure that you've thought of everything that you own. It's important. We recommend that anybody who writes a will with us uses Life Locker, because otherwise you're naming an executor and not giving them a chance. You're not giving them a fair chance to be able to locate and gather up your assets. So if you do step through the Life Locker service, and that service can be stored in the cloud, you can actually name your executor as what we call a key holder. And then with that unique key holder ID, they can log in as a key holder and get access to your Life Locker, which is an inventory of all of your assets and all of the people to contact. It becomes like a handbook for your executor. If you don't want to use Life Locker, you don't have to. You can use a spreadsheet as long as your executor knows where it is. You can even use a little notebook. But the nice thing about the Life Locker service is that it's secure. Only your key holder is ever going to be able to see it. It's encrypted in the cloud. You can update it very easily by just logging into your account and making those changes. And it can't be accessed prematurely. You don't really want people to go and seeing the extent of your assets when it's not the time to do that. So there's safeguards to make sure that your executor or anybody else doesn't prematurely log in and view your entire financial profile. So If you haven't seen it, if you haven't seen LifeLocker, I would suggest that you take a look at it. It's the best way to document the components that go into a residual estate. My last comment about the residual estate as well is that in your will, you don't just name a beneficiary for your residual estate. You've got to have an alternate plan. You've got to have a backup plan in case that first choice person doesn't survive you for whatever reason. So a beneficiary for your residual estate and a backup plan. Okay, that was a long answer, but I touched on a few different things there. So we've got some questions that have come in. How is a power of attorney invoked? You know what? I read that. I said revoked. I thought it said revoked, but it's not. It's invoked. How does a power of attorney suddenly come into effect? It's a great question. There are different types of power of attorney. There is an immediate power of attorney, comes into effect the day you sign it. Generally speaking, that's not an estate planning tool. That would be used if, for example, you were traveling and you wanted somebody to sell your car for you that was back home and you're in Africa. You're going to give somebody a power of attorney to have that power. So it's not usually giving people general financial powers. It's a specific, immediate power of attorney that allows them to take care of something. It's unusual to create a general financial power of attorney to come into effect immediately, because a power of attorney is giving that person unfettered access to every asset that you own, every financial asset. So you wouldn't do that. But it exists, an immediate power of attorney. And then there's two interchangeably used terms: an enduring power of attorney. An enduring power of attorney is one that's in effect and continues to be in effect even after you've lost capacity. I didn't turn that over. It continues to be in effect even after you lose capacity. There's a final type, which is a springing power of attorney. Now, people use the enduring and the springing interchangeably, but the actual correct definition is a springing power of attorney. It doesn't do anything until the person loses capacity, and then it springs into effect. I'm assuming that this question is about that type of power of attorney. So the power of attorney will say within it what the requirements are for that power of attorney, or that person's incapacity to be determined. So it's going to say this power of attorney will come into effect on incapacity. Well, what's incapacity? Who's going to determine that, right? And it happens all the time where it's like, I don't know, Mum's 95 years old, and I think she's just bought a bunch of crypto. I don't really think she knows what she's up to. So you have to. So the requirement for determining incapacity is to have it's written into the document, and the document usually says one or two medical practitioners, physicians, or capacity assessors. There's a capacity assessor. That's a job where people can go and meet with the individual and assess whether they have capacity. Once that capacity is determined by the physician or the capacity assessor, medical practitioner, or whoever, they would provide you with some documentation, a certificate to say this person no longer has capacity to handle their own finances. And then that document is then invoked. It's then, at that point, it's an active document, and that will then allow that person who has been assigned the representative to start to go to banks and the financial institutions and say, this person has lost capacity. Here's my certificate from a capacity assessor. Here is the power of attorney. I am now their representative. I am now going to take control of their financial assets. So it's capacity, and it's determined by somebody who in general terms, has the authority and the qualifications to determine that that person no longer has the capacity. Right, I haven't read this one. I'm just going to put it up. Person dies with a will, and the testator's wife is the only beneficiary. Would it be necessary to probate the will? Several children are surviving the testator, but minimal chances of contesting. This depends. It depends on, and there's going to be a lot of it depends. So this one depends on how the assets are held and the nature of the assets as well. So it's quite possible that the testator could be married and have a number of assets that are in their name only, like a house. And the house needs to transfer to the spouse, but the spouse is not, it might be a second marriage, it might be a recent marriage, very recent marriage. And so those assets are all individually held and they have to transfer to the wife in this situation. So financial institutions, often it's the financial institutions that require and determine whether they are prepared to release or transfer funds with or without probate. And we've talked about this previously, where it's almost like a risk that the bank has to take on. When somebody shows up to a bank and says, I'm the executor, and this one, it doesn't say who the executor is, but this person shows up and says, I'm the executor, there's $500,000 in the account, I need to move those $500,000 to this person. This person's the spouse, you're good. Well, if the account was jointly held, the bank would say, you know what, no problem, I'll move that over. I'll give that, we'll put it in the spouse's name only. But if there's no joint owner of that asset, the bank may perceive there to be a risk of releasing the funds to the executor. So they say, no, we need to have, that executor needs to have that grant of probate. We need to know that the will that says the wife is the only beneficiary is actually the official last will and testament. There may be another will that says half of my assets are going to go to my children and the remainder is going to go to the spouse. So the bank is going to have their own determination, and oftentimes there is a documented threshold of the amount of money that they are prepared to work with the executor before probate is required. So it really comes down to, in many cases, ultimately this would come down to the nature of the assets, how they are held, whether it's jointly held or individually held, and whether any of the organizations, whether it's a government department or a bank, whether any of those determine that that probate is required in order for them to release the assets. Where can I find a reputable third-party executor service provider? It comes up so much. There's so many times we're asked this. And we do know of some companies that provide this service. So let's look at some of the options. For us, like people using our service, most people who use our service name a friend or family member as their executor. There's advantages to that. Primarily, the main advantages are that oftentimes they are also the beneficiary. Helps. They usually have a better sense of what your assets are. So that can help too. They're just more intimately aware of you as a person. So there are advantages to naming a friend or family member. The clear disadvantages are twofold. One, they might not be capable or have the qualifications or the knowledge to actually perform the role. That's one of the main disadvantages. And the other one is they may be in no fit mental state to be doing all of this stuff because you've just died. They may be grieving, they may be traumatized. We don't know the nature of your death. So this person may not be ready to be dealing with the bureaucracy of working with the revenue agency, for example. So that's one of the disadvantages. For the first disadvantage, the other advantage, of course, is that they're not going to charge you a ton, because if they're the beneficiary as well, then oftentimes they're not going to take the amount that's allowed for them to take. There's a percentage of the estate that they could take as executive compensation, and oftentimes that would be waived if it's a friend or family member. But the other important thing to keep in mind is that this person can always hire professional help whenever they need it. Accountants, lawyers, they can bring people in if they're out of their depth, no problem. But they're named as the executor, but they can hire professionals as and when needed. It's actually a pretty solid approach. But your other options are a lawyer, a law firm. They can certainly do it. And oftentimes, if a lawyer has been involved in the writing of the will, some do, some don't. Some like to have the role of executor. Others, quite frankly, don't want to take it on. It can be a lot of work. So I certainly know some lawyers who no, I never want to be named as the executor. But it can be quite lucrative because, as I mentioned, your executor fees are a percentage of the estate. So if the estate is quite straightforward, and the lawyer can take care of things like transferring ownership of the house, and if they are going to give themselves like 4 or 5% of the value of the estate, that can be a lot of money for not that much work. So some lawyers certainly like to take that on. So a law firm can certainly do it. The other one is banks, and most major banks have an executor trustee service, and you can work with them. So there's a couple of caveats to that. Firstly, yes, it's expensive. It can be. They're going to take a good percentage of the estate. They can legitimately refuse. Like if you haven't run it by them first, and suddenly it pops up and says, "Well, you're the executor of John Doe's estate," it's like, we don't want that. We're not touching that. So you've got to have approval from that third-party professional service before you start naming them in the will. And additional to that is that some of them, if they're going to be named as the executor, are going to say, "Yeah, we'll do it, but put this clause in the will." There's a very important clause that we insist is in all of the wills if we are going to take on that responsibility. So they may have specific requirements for the actual document before they're prepared to take on that role and responsibility. So that's one other option. There are also third-party independent services. There's one called Clear Estate in Canada. There's one called King's Trust, I think, in London, in the UK. There are. You can look for professional executor trustee services, and they do pop up. There's one in Canada called Financial Concierge. They do this as well. And I've personally met with them. Seem like a great company to work with. So I don't know where you are. Where can I find a reputable third-party executor service? I will mention one that if all else fails, the provincial, let's assume you're in Canada, the provincial Department of Guardian and Trustee, the Public Guardian and Trustee Service, they could do it. It's really a last resort. You're going to be there as a file number. There's no idea. There's no telling when they're going to get to you. It can take a long time for them to get to you. I certainly wouldn't recommend in your will that you appoint the public guardian and trustee to be the executor in your will. But that is another option. So do we have a recommendation? Not really. And it really depends on where you're located. But you can maybe contact me. I might be able to find somebody in your jurisdiction. I'm going to take one more. Can I make 2 separate valid wills with my legal will software And how do the wills cross-reference each other to take advantage of the Ontario first dealing exemption for probate on real estate? Okay, so you're in Ontario. This comes up from time to time, and it is a dual will strategy. It's used particularly for corporate assets. The idea being that probate estate administration taxes are levied as a percentage on the size of your estate. So if you can put some of those assets into a non-probated will, then you're reducing the size of your estate, and the estate administration taxes, the probate taxes, will be lower because the assets covered by your will, many of them have been moved into a non-probated will. That's the strategy. Can you do it illegal wills? No. Yeah, the short answer is no, you cannot. We don't support that. It's a advanced estate planning technique. It requires professional advice, and not just from any lawyer. Don't just walk into the door of the first lawyer you see. It's got to be a lawyer who deals specifically in wills and estates, knows what the implications are of putting different assets into different wills, moving assets back and forth between them. You would have to have a long-standing relationship with that estate planning lawyer, and they would have to have expertise. It's one of the situations, and we do have an onboarding, a legal wills, to say whether our service is suitable for you. This would be one where it's not. You could certainly prepare your will. Like we do recommend that you write your will. Everybody should be writing their will. You may not get around to doing this. I mean, let's face it. People don't get around to even writing their will. So you may not get around to meeting with that seasoned, experienced, qualified estate planning lawyer who's going to be able to arrange your assets in this way. So my recommendation is, if you don't have a will, get it done now, and then start to look into this, explore this as an option. And there would be no harm in having your will written through legal wills if down the road you eventually realize that a two will, a dual will, corporate will structure is better for your assets. You've lost $49.95, which will pale into insignificance when you receive the invoice from this experienced estate planning lawyer who has set up a dual will strategy for you. So with that, we've kind of got to the end of the half an hour. I wanted to do one more if we can. I'm going to do this one. So, is there a difference in preparing wills if we are officially married or not married? Officially married, living together, common law, and so living as a married couple and actually being married. Or, yeah, let's leave it at that. Yes, there is a difference, but it's subtle compared to the difference between the situations of dying without a will. And I think that's the most important piece of information to really convey here. If you are living in a common law relationship, you are living as a couple, but you never officially got married, you're going to have to look at your local laws in your province and in your state, because every province and state has a different determination for what would happen if you died without a will in place. The really important message here is that none of them, well, So some provinces will say, well, if you've lived together for 2 years, that counts. So if you die without a will and you've lived together for 2 years, then that common law spouse has a right to make a claim on the estate, and they have a right to their share. But by no means all. Not all jurisdictions do that. You never ever assume that, well, we've lived together for 30 years. I know we didn't technically do the paperwork to get married, but we've lived together for 30 years. If you do not have a will, there's a very good chance that you could die and your common law partner would not automatically have a right to a share of your assets. So the message here is that some people feel that the institution of marriage is antiquated, anachronistic, it doesn't belong anymore. That's fine. That's fine. That's cool. If your belief is that you don't want to get married, or you might not just never got around to it, write a will. Write a will, please, because you are taking a chance of that person being able to claim something. And at best, even if they did have a claim, it's going to be, you're going to put them through the ringer because they're going to have to make a claim. The will makes things just so simpler, right? Everything to my common law spouse, it just makes things so easier if you have that will in place, compared to not having a will and your common law partner is going to have to make a claim. And hopefully, maybe one day they might get what they would have got anyway, but maybe not. Maybe in your jurisdiction, it's not recognized. So that would be the message here. When it comes to actually writing the will, actually, no. Like, unless you're disinheriting each other, which I'm assuming you're not, if you're going to name each other as your main beneficiary, it doesn't really matter whether you're married or common law. You're saying, I'm going to leave my entire estate to my spouse or my common law partner, this person. It works equally well. So yeah, if you're writing a will, there's not too much difference. There may be, but for most people, it wouldn't really make a difference. So with that, coming to the end, thank you once again, everybody, for attending, putting up your questions. I always enjoy seeing the questions that people have. Hopefully I can give some clear answers to some potentially confusing issues around estate planning documents. So thank you so much for taking the time to join me. I really appreciate it. If anybody has any other questions or I didn't get to their question, by all means, tim@legalwills.ca. Happy to receive your email, and I will get back to you.